If you passed away tonight, your spouse could not withdraw a single dollar from your bank account tomorrow morning. Not with a will, not with a power of attorney, not with a notarized letter from your attorney. None of that matters at the teller window. There is one short form, free at almost every bank in the country, that fixes this completely. And almost nobody tells you it exists because the people who could tell you don't get paid when you find out on your own. Make sure to hit subscribe and turn on notifications right now, because every week I cover the real financial information that affects seniors directly, the rules that changed, the protections you already qualify for, and the steps that actually make a difference. This is exactly the kind of content I put out every single week, and you do not want to miss it. Now, let's get into it. The disaster I see most often isn't a bad investment or a missed tax deadline. It's a grieving family standing at a bank counter being told the money sitting right there, legally theirs, is untouchable because of a form nobody ever filed. That form takes about 10 minutes. It's free at the vast majority of banks and credit unions. You don't need a lawyer. And unless someone hands you this exact information, you will probably never hear about it from the people who could have told you years ago. Hashtag the legal track nobody explains to you. Back in 1969, the Uniform Probate Code set up a rule most Americans have no idea exists. Money sitting in a bank account isn't governed by your will. It's governed by the contract you signed when you opened the account. Every state has since adopted some version of this, and courts keep upholding it. In plain English, the paperwork on file at your bank beats your will every time, no exceptions. Your will controls your house, your car, your grandmother's ring. It has zero authority over your checking account. Die without a named beneficiary on that account, and the money doesn't go to your family, it goes to your estate. The second that happens, probate is on the table. Every state allows a simplified, faster process for smaller estates, and that small estate cutoff varies enormously depending on where you live. Some states draw the line under $30,000. Others set it well above $150,000. The point isn't the exact number where you live. It's that plenty of ordinary retirement accounts sit comfortably above whatever that number is, which means full, court-supervised probate, not the shortcut. People assume probate is a quick formality. It usually isn't. Many states build in a mandatory creditor window, often somewhere in the 3 to 6 month range, where anyone who might be owed money, hospitals, credit card companies, anyone gets a chance to file a claim before the family sees a cent. Meanwhile, the funeral home still wants paying this week. Hashtag Walter's story. Walter was 68, a retired union electrician in Ohio. He sold his late wife's jewelry and some land he'd inherited and walked into his bank with roughly $290,000. He opened a savings account, paid an attorney $750 for a clean, properly witnessed will naming his 2 kids, James and Priya, as equal heirs. He filed the will in a drawer at home and figured the hard part was over. It wasn't. Walter passed unexpectedly. His kids flew in, got hit with a $9,800 funeral bill, and brought the will and death certificate to his branch. The manager pulled up the account, saw only Walter's name on the contract, and explained there was nothing she could legally release. No beneficiary designation, balance over the state threshold, account frozen. James and Priya put the funeral on a credit card at over 20% interest, while $250,000 of their father's money sat behind the same counter they'd just been turned away from. Then came probate, a $350 filing fee to open the estate, a required newspaper notice running 3 weeks to alert unknown creditors at $230, a $900 executor bond. The attorney's fee, calculated as a percentage of the estate, came to roughly $9,000. Fee structures like this are common, but not universal, and some states cap or prohibit percentage-based probate fees. So it's worth checking how your own state handles it. The creditor window held everything up for months. All in, the family waited just over a year to access the money and lost close to $11,000 along the way. On top of the credit card interest that never stopped accruing, Walter didn't make a mistake. He did what he was told to do. The will, the attorney, the notary, none of it touched the bank account because none of it was ever supposed to. The will and the bank account were always two separate systems, and nobody had explained that to him. Hack 3 ways this trap gets set without anyone noticing no beneficiary on file. This is the most common one. You opened the account years ago. Nobody asked about a beneficiary. You assumed the will covered it. Estate attorneys draft wills. They almost never file bank forms because those are two separate documents at two separate institutions and nobody connects the dots for you. A stale beneficiary designation. Worse than having none because it feels handled. Maybe you named an ex-spouse decades ago or a parent who's since passed. That name is still what the bank has on file, and that's who gets paid, regardless of what your current will says. Court side with the bank's paperwork every time. Assuming marriage covers it. Plenty of couples assume everything passes automatically to the surviving spouse. In many states, that's only true if the account is specifically titled as joint with right of survivorship. And marriage alone doesn't always create that automatically, so it's worth confirming exactly how your accounts are titled, rather than guessing. And here's the trap inside the fix people try on their own: adding an adult child as a joint owner so they can help pay bills. That sounds harmless, but in many states, the law treats a joint owner as having an immediate, present interest in that money, not just a future one. That means if your child is sued, goes through a divorce, or owes back taxes, a creditor or a court can sometimes argue that a share of the account belongs to your child right now, while you're both still alive. The rules on exactly how much exposure exists vary by state and by how the dispute plays out. But the basic risk is real enough that estate attorneys generally steer people away from adding a child as a joint owner, purely for convenience. A pod designation gets you the same convenience. Your chosen person can step in immediately after your death without exposing the money to their creditors. While you're both alive, the form that sidesteps all of it. It's called a payable on death designation, or POD. It traces back to a 1904 New York case, matter of Totten, which allowed money to pass directly to another person without a trust or court order. That principle is now written into the Uniform Probate Code and adopted nationwide. A POD isn't a will and isn't a trust. It's an instruction sitting on the same contractual track that froze Walter's account, which is exactly why it works. Your beneficiary shows up with a death certificate, the bank checks the form on file, and the money moves. No judge, no attorney, no waiting period. Smaller banks can often process it the same day. Bigger institutions usually take 3 to 5 business days. It costs nothing to file because it generates the bank no fees. It only protects you. Hashtag what a POD doesn't cover. A POD covers your checking, savings, and money market accounts. It does not automatically cover CDs. Each certificate of deposit is its own contract and needs its own designation, even at the same bank. Brokerage accounts. These use a transfer on death, TOD form instead, filed with your brokerage, not your bank. Retirement accounts, IRAs and 401ks already work this way by design, but most people set the beneficiary decades ago and never updated it. For employer plans like a 401k, federal law generally says the beneficiary on file controls, even over a will, and the Supreme Court has upheld that principle. IRAs work a little differently. They're typically governed by the custodian's paperwork and state law rather than that same federal framework. And a number of states do automatically revoke an ex-spouse's beneficiary after a divorce. But that protection isn't universal. The rules vary by state. and plenty of people still get caught out. The safest move either way is the same. Don't assume an old form is fine. Check it and update it yourself. Safe deposit boxes. In many states, banks seal these the moment they're notified of a death, though the exact rule and how easily a will can be pulled out for a quick will search varies a lot by state. A spare key won't necessarily get your family in on its own. If the will is locked inside, you can run into a frustrating circular problem. They need the will to open probate, but in some states, they need a probate order or at least a formal request to open the box. The simplest fix is to never make your will the only copy in the box. Keep a copy somewhere your family can reach immediately, and consider adding a trusted person as a joint renter on the box itself so they retain access regardless of what happens to you. Hashtag what to actually do this week. 1. Ask your bank, in person or online, for the payable on death designation form. It's standard practice at virtually every bank and credit union in the country, and it's free. If a teller doesn't recognize the term, ask for the branch manager or ask about a POD or in trust for designation instead. 2. Name a primary beneficiary with their full legal name, date of birth, and social security number, not my kids. Vague language slows the bank down right when speed matters most. 3. Name a contingent beneficiary too, in case your first choice doesn't outlive you. Without one, a lapsed designation can send the account right back into probate. 4. Get written confirmation the form was recorded, and file it with your important papers, not in a drawer no one else knows about. 5. Repeat this for every account separately, checking, savings, and each individual CD. Each one is its own contract with the bank, so a designation on one account doesn't carry over to another, even at the same branch. 6. Call your brokerage and file a TOD for any investment accounts outside retirement plans. The form looks similar to a POD, but it has to be filed separately with the brokerage, not the bank. 7. Pull up your retirement account beneficiaries and update anything outdated, especially if it's been more than a few years or if your life circumstances have changed since you last looked at it. 8. Revisit all of it every few years or after a death, marriage, divorce, or new grandchild. Estate planning isn't a one-time task. It's a maintenance habit. A reasonable question at this point is whether a PO designation replaces a will entirely. It doesn't. A will still controls property that doesn't have its own beneficiary designation. Your home, your car, personal belongings, anything titled only in your name. A POD or TOD form simply takes your bank and brokerage accounts off that track entirely, so they never have to wait for the rest of the estate to work its way through court. Think of it as removing the single biggest, slowest moving piece from the puzzle, not replacing the puzzle. Tonight, as things stand, your family can't touch that money. That changes the moment you file one free form. Go ask your bank for it this week. And if this was useful, subscribe.